and Mr. Whalen to read their statement to the jury and nothing else. And I'll make reference to what I've redacted in just a minute. As far as the continuance motion, I'll deny that without prejudice. We'll see where we are as far as the posture of the case is once the witnesses have testified. So I'll consider that at a separate time if that becomes necessary. Regarding the defense motion limine, I'll agree to grant that motion. It seems to be a small issue. I'll require the state and defense to refer to the mitigation as mitigating factors and not designate them as statutory or non-statutory mitigating factors. Now, the portions I've redacted in Sheriff Mascara's statement are the ones that I've highlighted here in yellow. And I know they may need a few minutes to take a look at them, but the portion, I'll read them into the record, but I'll make a court exhibit, but what's the next number? It'll be Court's Exhibit 6, but the portion I've elected to redact, as I think it may not be appropriate victim impact evidence, are highlighted in yellow, specifically as far as Sheriff Mascara's statement is concerned, where he says, "I want to thank each one of you for your service as a juror on this case." That's a function of the court later on, not a witness. The second paragraph where it begins, "I also want to answer the question that all of you have, what happened to my hair? The disappearance of my hair underscores the brotherhood of law enforcement, first responders in general. We have an employee who's battling leukemia, and a side effect of his treatment is thinning and loss of his hair. So his coworkers and supervisors, all the way to me, decided to shave our heads in solidarity and support. Many years ago, I read a Wall Street Journal article which highlighted the bond of Many years ago, I read a Wall Street Journal article which highlighted the bond of workers, that the average worker will spend more time together than they will with their own family. That I will exercise my discretion, require that not be read. The rest of it on page 1 I find to be acceptable. On page 2, the third full paragraph, I will require not be read, as I, in my view, don't find that to be appropriate victim impact evidence, where the paragraph reads, "As the media were broadcasting live from the scene, my phone began to ring nonstop. I didn't answer, but soon realized my voicemailbox was full. The governor, the Florida Attorney General, and sheriffs from all over the country left voice messages expressing their condolences and offering support. To this day, I still have them on my phone. I'll agree to excise that." On page 3, down on the bottom where it says there, "Holly and I were met by Vice President Joe Biden, who offered sympathies and support." I will agree to excise. The only other part I'll agree to excise on page 6, the fourth paragraph from the bottom, where it says, "I think you would agree that Gary possessed all the best qualities we want a deputy sheriff serving our public in a time of crisis. For you and or a loved one, you would want him coming to your rescue." I will excise the part where it says, "I think you would agree that," and the part where it says, "in a time of crisis for you and a loved one, you would want him coming to your rescue." I will permit the sheriff, if he wishes, to read, "Gary possessed all the best qualities we want in a deputy sheriff serving our public," and excise the other parts. And finally, on page 7, the last paragraph where it says, "Collectively, we all lost a hero, and nowadays those are few and far between." I've excised the part where it says collectively, and nowadays those are few and far between. I will permit the sheriff to read, if he wishes, "We all lost a hero," period. There's the letter from Mrs. Morales I find to be appropriate victim impact evidence, and will decline to excise any portion of that. The parent's letter I find to be appropriate under these circumstances, will not excise any of that. As far as Mr. Whalen's letter, in the first paragraph down where Mr. Whalen writes, "He is a deputy you would want to get pulled over by," I will agree to excise that. On the second page of Mr. Whalen's letter, where he writes, "I couldn't save the man that saved my life. If there was anything I could do to change that point in time or take a bullet for him, I would have." I'll agree to excise that portion of his comments, as I find under these circumstances that would be inappropriate victim impact evidence. And that's it. So I don't know if y'all want to, how you want to do it, but I've highlighted, these are the only two
Okay. We'll do that, and then we'll email it to Leslie, and then that'll be...
Okay, now the parts I haven't, I note the defense objection, and we'll overrule those for the reasons I've stated. Now, these two I'll make, okay, so it's Court's Exhibit 10. Okay. These are copies of the letters from Mrs. Morales and one of Sergeant Morales' parents that I'm not redacting. Now, yes. All right, now, I just ask that they read those portions. If there's something else they want to present, we need to take it up outside the jury. So
we've given all of them very explicit instructions that they are to read their statements and only their statements. Okay. The only additional thing is there is a photograph which we provided the defense that Sheriff Mascara will be offering, and that's been marked up there.
All right, defense have any other comment on the photograph?
No, I made my objection.
Under the defense objection, I find it to be appropriate victim impact. I'm asking, I presume the children are Sergeant Morales' children?
Yes, sir.
Okay. All right, I'll permit the state to present that via Sheriff Mascara, whichever witness they prefer. That's identified as State's Exhibit 128 for identification. Okay.
Judge, did you want to rule on the renewing of our motions that we filed that you denied for the penalty phase, all those motions?
Yeah, let's see, that order was entered May 20th, 2015. I'll note the defense continuing objection will overrule them for the reasons I put in that order regarding the penalty phase proceeding. Now, I've got this instruction I think I'm obligated to give when we commence. The first reads, when the jury comes in, of course. Ladies and gentlemen of the jury, you have found the defendant guilty of murder in the first degree. The punishment for this crime is either death or life imprisonment without possibility of parole. The final decision as to which punishment shall be imposed rests with the judge of this court. However, the law requires that you, the jury, render to the court an advisory sentence as to which punishment should be imposed upon the defendant. The state and defendant may now present evidence relative to the nature of the crime and the character, background, or life of the defendant. You are instructed that this evidence, when considered with the evidence you have already heard, is presented in order that you might determine first whether sufficient aggravating circumstances exist that would justify the imposition of the death penalty, and second, whether there are mitigating circumstances sufficient to outweigh the aggravating circumstances, if any. At the conclusion of taking the evidence and after arguing with counsel, you'll be instructed on the factors in aggravation and mitigation that you may consider. All right, state, have any objection to that being read?
No, sir.
Defense?
No, Your Honor.
Okay. All right, I'm not sure they're all up yet.
Done yet, sir.
We're missing one. Okay, we're missing one. The only other thing, in Mr. Whalen's letter, it never identified who he was, so if y'all want to ask him his name or have him put in there.
Right, I expected that we would call each up, have them state their name.
That's fine. Just the others I think did maybe, but if you just make sure you identify who they are for the
Yes,
record.
sir.
So. Okay, when they're all up, we'll bring them in and commence.
Yes, sir.
Okay, if y'all bear with me, as soon as they're all here, we'll come back in and get started. Okay, thank you for bearing with me. We'll go off the record. If y'all want to make those corrections, please.